Welcome to Atlanta Estate Planning with Terry McGinn.
Hello, everybody. Thanks for joining the podcast. My name's Terry McGinn. I'm an attorney. I practice probate and estate planning law in Atlanta and the surrounding areas and basically all over Georgia. So what I'd like to talk about today is trusts. I get a lot of questions about trusts. People have gone on the internet. They say, well, I've heard this about trust, that about trust. What is a trust and what does it do? So I'm going to talk about trust today in this podcast. I'm going to go through and give you some examples of the various basic kinds of trusts there are in general. And then I'm going to go through the factors for a valid creation of a trust, which I think is important. So let me just start off by saying I get a common question. What is a trust? Okay. A trust is a legal arrangement where one party, the grantor, the owner of the property that's going to be transferred into the trust, holds and manages the assets of the property, and that is a party they're going to designate to hold and manage the assets of the trust. And that person is called a trustee for the benefit or on behalf of the benefit of another party. And, benefit for another party, they're called beneficiaries. And as directed by the settlor, or I'm going to say a couple of terms here, but settlor and grantor are the same person, who is the owner of the property. So it's a tiered arrangement. It's a structured arrangement where a person that owns property entrusts the property to an agent, a trustee, for the benefit of a person to whom the grantor wishes to have the property given to. There are kinds, and what are the main benefits of a trust? I always get that. You avoid probate. The probate process is when you die, whether you have a will or not. A probate court, a judge will come in and look at what assets are in your possession and ownership at the time you die, and will decide whether there's a will or not, whether or not the court will direct the distribution of those assets. Another topic for another time for wills. And the main reason why people want to do a trust instead of a will is they want to avoid probate, which is the process I just talked about. Georgia's a pretty benign state about trusts and trust, because probate in Georgia for wills, whether you have a will or not, lasts anywhere from 90 days to 4 months. And then typically the property is distributed and the administration of the estate then is closed thereafter. Some states, it's a year or two. And I get a lot of people calling me saying, well, I heard in Illinois, for example, that it's 2 years. Georgia's pretty benign about that. Our probate process is pretty simplified, although it's complicated. And you have to be careful about the forms you file, etc. However, unless there's an objection to the probate process, which would string it out for a year or two, I do probate litigation as well. Trust probates in Georgia are pretty benign, but people still feel like, I want to avoid probate at all costs. A trust will accomplish that. So a trust, as we said before, is a document where the grantor, the owner of the property, puts the property into a trust, and upon death of the grantor, that property is immune from probate, doesn't go through probate, because it's not owned by the person who became deceased. And the trustee, depending on how the trust is worded, will administer the trust according to how the grantor, the person that wrote the trust, wanted that property distributed. So that's one of the main motivations to have a trust, to avoid probate. There are various kinds of trusts. There's a revocable trust and irrevocable trust. In that, there's revocable living trusts and revocable living trust. And then there's testamentary trust. I'll get into that in a minute. So a revocable living trust transfers the property now and can be dissolved for any reason or no reason at all. So I create a trust for my family. I put my real estate into a revocable living family trust 5 years from now. And in that process, a deed is created transferring my real estate, as an example, from my name and my wife's name into the name of the trust. And we'll talk about the deed transfer and all that in a second. But it needs to be legally transferred from our names to the name of the trust. And that document, the deed, it's typically a quick claim deed I prepare, is filed of record in the Superior Court Clerk's office in the county where you're located. If you're outside of Georgia, it's probably close to that. Same procedure is probably close to that. So that's a living revocable trust. One of the issues with a trust, people always ask me, well, I also want to protect my property. A revocable trust does not afford any real protection for property that is in the name of the trust from creditors or other people that like to make a claim against it. So that's a distinction that most people aren't aware of. There's no real asset protection in a revocable living trust. Let's talk about an irrevocable living trust. And when I say living trust, I mean the trust is created now. At the time that the client walks through the door and says, I want to create a trust, we do the trust, we write it, we transfer all the property over. That happens now, currently. An irrevocable living trust is the same thing. Client comes through the door, I create the irrevocability of the trust. The assets are transferred from the grantor, the owner, to the trust, and the trustee is the person that's going to administer it, exactly like a revocable living trust. What does the irrevocability mean? It's a permanent legal arrangement where transfer of assets to a trust for the beneficiaries are set in stone. They cannot normally be changed or canceled. That's a real issue with a lot of people, because what that in effect says is the grantor surrenders all rights and ownerships of the asset and can't normally get it back. People are surprised when I let them know that. In exchange for your surrendering of the asset's control to a trustee who you have to nominate, I'll tell you in a minute about the qualifications, but in exchange for that, you're getting a benefit which an irrevocable trust does provide a very great deal of creditor protection. People, you're really, because there's a wall between you and the asset, but creditors can't directly attack the asset because you're no longer in control of the asset. And that stands up in most states. But you're surrendering your control of the asset, which is an issue that a lot of people have when they say, I insist on an irrevocable trust. When I explain to them what the issue is legally about lack of control, that in a lot of cases changes their perception of what they want. So, but not always, and that's fine. You just have to know up front what you're getting into. There is the potential for limited modifications of an irrevocable trust, but all the beneficiaries and the grantor must agree in writing, and or a court can order that the trust be transformed from an irrevocable trust to a revocable trust, as long as the order fulfills the trust's original intention or purpose. Hard to do, though. It's very hard to do, to go ahead and modify the terms of an irrevocable trust. So those are living trusts, revocable and irrevocable. What is an irrevocable testamentary trust? Testamentary. So that's a trust that's created by a will. And I do those all the time. They're called pour-over wills. And in the wording in the will that I create, a trust will be created only, though, after the testator, the person that's written the will, passes away. So here's the normal scenario I run into. I do a couple of these every month. A young family comes to me. They have minor children, and they want to create a trust in the event both of them become deceased for the benefit of their minor children. That's where a pour-over will comes into question. And the structure of it is the trust does not come into existence. It's not a living trust. It doesn't come into existence until either the grantor, the owners of the property, both become deceased. So God forbid a young mom and dad come in and they're killed in an automobile accident, or one dies and then the other one dies, where their children are below a certain age typically. So there's a facet to this that's outside of a trust. In my pour-over wills, I have a place where they nominate guardians. So, for example, the guardian that they appoint is only going to be effective unless and until both the parents become deceased for minor children. Who is that going to be? It can be a relative or a friend, somebody. But I really recommend, if there are minor children involved, they do appoint a guardian. And that's outside of the trust. That's a separate clause in my pour-over wills. What about the trust itself? They have to nominate a trustee, again, who's the middle person who takes control of the assets in the trust and is responsible legally to make sure that those assets are preserved, and the funds that are in the final estate are paid for valid reasons to the guardians who they have appointed. And so that's basically where we're at. So a trustee has plenary powers, has a lot of power in Georgia and most other states to decide what funds are going to be paid for the care, upkeep, and maintenance of the minor children while they're still minors. In Georgia, minors no longer minors after they reach the age of 18, in which case the guardianship dissolves in most cases. But so there's an implied legal tension between the trustee that you've named and the guardian of your minor children. After 18, as I say, the guardianship dissolves. But the trust doesn't necessarily dissolve at 18. In fact, I don't recommend the trust dissolve at 18. What I recommend is you give a different age for the dissolution of the trust. So, for example, family comes in, they have 2 children, they're 3 and they're 8. So the 8-year-old, what I normally say is, I wouldn't recommend having the trust dissolve when your 8-year-old 10 years from now reaches the age of majority. Because what would happen, you can do that. And some people decide it's fine, I trust my child. I couldn't have handled bubblegum money when I was 18. But that's just me. So the bottom line is, when somebody reaches a target age, I put that age in the trust documents so that child's portion of the trust, typically it's an equal distribution of the assets. When the child reaches the age of, can be 18, I normally recommend 21 to 25. 21, they're normally done with any education. 25, if they're going to other advanced degrees, etc. But they can go in and talk about that, and do that. So then that portion of the trust dissolves for them. The other requirement is it must be in a will. It's got to be specified in the will, and it's not necessarily funded at the time of the will. So that's the issue on that. And so that's called an irrevocable testamentary trust. Let's talk briefly in my remaining couple of minutes here about how the trust what are the requirements of a trust. First of all, the trust has got to be in writing. Second, there's got to be property transferred to the trust. There's whether you're doing real estate, personal property, etc., etc. It's got to be listed in the trust. And if it's real estate, like I said, a deed needs to transfer the property from the trust directly over to the trust and filed of record in the Superior Court Clerk's office. So it's got to be in writing. There's a property requirement we just talked about, and you got to list a beneficiary. The other thing about the beneficiary is, I have it happen all the time. A person comes in, I own the property, I'm the grantor of the trust. I'm going to appoint a trustee, but I'm also going to be the sole beneficiary. I don't have any children. I don't have any grandchildren. I want to be the sole beneficiary. And then when I pass away, I want all the property that I want the trust to dissolve. The problem is, in that limited scenario, that's not a valid trust. A person that's the sole grantor, and possibly the trustee too, a grantor and trustee can be the same person, but cannot be the sole beneficiary. There's got to be a listed beneficiary who is being paid from the benefit account that survives or has a mechanism to survive if the grantor passes away. So that would be an invalid trust. So in sum, there's got to, and the other major thing about the factors is the grantor, the person owning the property, has to be competent to write the trust, to be able to know what he or she is doing at the time the trust is written, meaning there can't be any undue influence against the grantor. The grantor have to direct intention to do what they're doing, and the trust can't be written up for any unlawful purpose. You can't hide the assets in a trust to avoid creditors. So the guarantor's got to have capacity, know what he or she's doing. It's got to be in writing. There's got to be real property added to the trust in a schedule that's set up for it in the back. And there's got to be a knowing and an ascertainable beneficiary. So those are the general requirements of a trust. I hope I've answered a lot of the questions you might have. Please feel free to reach out to me. Go to my website. It's a fairly simple website. It's lawga.com, lawga.com. I'm Terry McGinn. Thanks for your time.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.